Dear students, today we shall discuss another important act, that is the Workmen's Compensation Act of 1923. In the previous classes we discussed about so many different acts which comes under labor legislation and also an important part under IR. They were Factories Act, then Maternity Benefit Act, then Provident Fund Act, Child Labor Act, Payment of Wages Act, Minimum Wages Act, ESI Act, uh, then Shops and Establishment Act, like that. So these acts are both applicable for the workers as well as employees, and again we will be differentiating these based on the category and also based on their the salary, monthly salary. So based on that we are going to differentiate them as workers and employees. So henceforth few acts are applicable to only employees and few are applicable only to the workers. So this again, the Compensation Act of 1923, it is more applicable to the workers than the employees working in service sector. Now let us see what is this and why this has been introduced and what are the objectives of this act. The objectives of this act includes, it is one of the important social security legislations which is been formed in the interest to protect the social security of the workers. It aims at providing financial protection to workmen and their dependents in case of accidental injury by means of payment of compensation by the employers. So in case of any accident, suppose if the workers meet in the working premises or work related accidents, for that in order to compensate for such problems that they have faced, maybe in terms of disability or sometimes death, no, this act has been introduced. So here before we proceed we have to understand some terminologies. They are commissioner, dependent, employer, disablement, wages and workmen, because these terminologies we will be discussing very often. Now the first terminology, that is commissioner, because he is the supreme in deciding or in providing acceptance for the issues that is being faced by the workers in with respect to any accidents that happens in the premises in the working condition. So for that reason we have to know the commissioner. He means a commissioner for a workman's compensation appointed under section 20 usually by the government. And dependent means any of the following relatives of a deceased workman, namely maybe a widow or a minor legitimate or adopted son and unmarried legitimate or adopted daughter or a widowed mother, anyone like that. So any dependent wholly on the earnings of the workman or maybe partially on the earnings of the workman, or maybe unmarried sisters or a widowed sister if a minor, or a widowed daughter-in-law a minor, like that. And the minor children, if there are any, they also will be considered as dependents. And the employer, we know anybody of the persons whether incorporated or not, any managing agent of an employer and the legal representatives of a deceased employer. And disablement means any loss of capacity to work or move may result in loss of reduction of his earning capacity, and disablement may be total or may be partial or temporary or permanent. So like this disablement is said to be the total when, if in capabilities or incapacitates which incapacitates a worker for all work he was capable of doing at the time of the accident, resulting in such disablement. and total disablement is considered to be permanent if a workman as a result of an accident suffers from the injury and specified in part 1 of schedule 1 or sufferers from such combination of injuries. Like the injury or disablement may be a temporary or permanent, or it is partial or whole complete, so it is considered as disablement. So on that basis the compensation will be provided. And the next important terminology is wage. We already know, because in most of the acts, in all the acts we will be discussing about wage, because many of the things is depending on the wage itself. And wage includes any privilege or benefit which is capable of being estimated in money in terms of monetary, which is being paid to the workers for their work, is considered as wage. And workman, a person employed in a factory with a suitable remuneration, is considered as workman. And entitlement is every employee, including those employed through a contractor but excluding casual employees, who is engaged for the purpose of employees business and who suffers an injury in any accident arising out of and in the cause of his employment, shall be entitled for compensation under the act. And workers employed in any capacity specified in schedule 2 of the act, which includes factories, mines, plantations, mechanically propelled vehicles, construction work, and certain other hazardous occupations and specified categories of railway servants. And the act extends to the whole of India except the states or union territories of Arunachal Pradesh, Mizoram, Nagaland, Sikkim, Diu, Daman, and Lakshadweep. So like this, some exceptions are there. And now let us understand what are the employer's liability to compensate any employee or a workman. To compensate any employee, such employee has suffered an accident arising out of and in the course of his employment, resulting into death, or permanent total disablement, or permanent partial disablement, or temporary disablement, whether total or partial, or who has contracted an occupational disease. Maybe because of long term work, the workman or worker might have met with long term illness or disease. So because of that also a compensation has to be paid. However, the employer shall not be liable in respect of any injury which does not result in the total or partial disablement of the workman for a period exceeding 3 days. That is, in respect of any injury not resulting in death caused by an accident which is directly attributable to the workman having been at the time thereof under the influence of drugs, or the willful disobedience of the workman to an order expressively given, or to a rule expressly framed for the purpose of securing the safety of workmen. Suppose in case of any negligence or disobedience by the worker in following the rules, or some the careful conditions that is being told, will not be considered for compensation. And in case of any influence under drugs and all, will not be considered. When the employee has contracted a disease which is not directly attributable to the specific injury caused by the accident or to the occupation, so in such conditions the compensation cannot be paid. And condition for receiving compensation for personal injury, the 3 tests for determining whether an accident arose out of employment or not is: at the time of injury, workman must have been engaged in the business of the employer and must not doing something of his personal benefit. That accident occurred at the place where he was performing his duties, and injury must have resulted from some risk accidental to the duties of the service or inherent in the nature or condition of employment. The general principles are there must be a causal connection between the injury and the accident and the work done in the course of employment, and the onus is upon the applicant to show that it was the work and the resulting strain which attributed to or aggravated the injury. So, these are certain principles that has to be followed because based on the clear acceptance only compensation will be paid, and for that reason they have to complete certain procedures, and in case the compensation has been approved and the person is been accepted for any kind of accident because of work related things, then the payment of compensation has to be made by the employer. And here again one more condition has to be met, that is, suppose if the employer or labor is a contract is working on contract basis, then the payment of compensation will be, that is, liable to pay compensation to contract labor in the same manner as is departmental labor. So, here also the contract labor also will be treated equally as that of the regular worker. So, on that basis he will be paid the compensation. And in certain conditions like occupational diseases, the workers employed in certain types of occupations are exposed to the risk of contracting certain diseases which are peculiar and inherent to those occupations. A worker contracting an occupational disease is deemed to have suffered an accident out of and in the course of employment, and the employer is liable to pay compensation for the same. So, like this, looking at the genuinity, the compensation will be paid, and the report, accident report, has to be provided where the accident results in death or serious bodily injuries. The employer should send a report to the commissioner within 7 days of the accident in the prescribed form, giving the circumstances attending the death or serious bodily injuries. And immediately the notice of the accident has to be brought to the commissioner, or it has to be sent to the commissioner by the concerned employee as soon as practicable after the happening thereof, so that the notice will be served to the concerned. And with respect to that, medical examination will be conducted, and the employer may get the concerned workman examined by a qualified medical practitioner within 3 days from the receiving the notice of accident, and the employee must present himself for such examination, otherwise he shall lose his right to the compensation. Failure of employer to have the workman medically examined does not debar him from challenging the medical certificate produced by the workman. And sometimes some fatal accidents may also occur, like where that may lead to sometimes circumstances like a death of the workman, or maybe the permanent disability. For such reasons also the employer disclaims his liability, and he should indicate the grounds for such disclaimer, and that has to be like within 30 days a notice has to be served, and a statement within prescribed form has to be submitted. And now we have to know about the amount of compensation. The amount of compensation payable to a workman depends on the nature of injury caused by the accident and the monthly wages of the workman concerned and the relevant factor. The relevant factor is specified in Schedule 4 for working out the lump sum amount of compensation. There is no distinction between an adult and a minor worker with respect to the amount of compensation. And compensation for death, in case of death resulting from injury, the amount of compensation shall be equal, that is 50% of monthly wages of the deceased workman multiplied by the relevant factor, or an amount of rupees 80,000, whichever is more. So here we have some calculation to with respect to that maximum the payment. So where in case workman is employed in a factory on a monthly wage of rupees 3,000, while working he met with an accident and dies on October 2000. His date of birth is July 1970. The amount of compensation payable to his dependent would be, again, whichever is higher. If we calculate, so whichever is higher, that has to be paid. So like this, again, in case of disablement, to declare such disablement as permanent disablement, then compensation shall be 60% of monthly wages, and in case of partial disablement, it is 40%. And in case any failure to pay such compensation, an employer is liable for the penalty for default, and a fine also has to be paid. And sometimes the funeral expenses also will be paid in case of death. So some nominal amount will be paid to the family. So these are the important conditions an employer has to meet for compensating the worker in case of any work related accidents or death. Thank you.